Now that we've discussed the procedure by which litigants seek court review, we'll discuss the politics of granting or denying certiorari because, like everything else the court does, it's political. And let's start with a fundamental question, and that is, why does the Supreme Court operate under the rule of 4? That is, why does it take only 4 votes rather than 5 votes to grant review to a case? Well, the reason for that is because the decision of whether or not to grant certiorari is supposed to be different from the decision on the merits, or in other words, the actual decision on the case. The certiorari decision is not supposed to be about whether the lower court got it right or got it wrong. In other words, you're not supposed to just grant review because you think the lower court got it wrong. Certiorari should only be granted if the case raises an important legal issue that needs to be settled. Usually it's a new legal issue, one the court's never addressed before, but it can also be something that's pressing out in the world, very important. And the court doesn't decide that many cases, and so the cases it does decide should be cases of significance. And so the vote on certiorari should not be, again, about the correctness of the case, but rather about the importance of the case. And the fact that they have a 4-vote threshold rather than a 5-vote threshold reinforces the fact that these 2 votes are indeed different and should be based on different criteria. And, of course, this does mean that a minority, at least at this point in the process, can hold sway. They may not ultimately win the case, maybe they will, but at least they can force the court to hear an issue if they can put together 4 votes. So that's why the court does not require a majority to grant review. So we're going to spend a lot of time talking about what happens to those cases for which cert is granted, but let's talk about what does it mean for all of those many 9,900 cases that do not get cert granted, that the court turns down. Why does the court do that? Why do they deny cert? And the fact of the matter is, who knows? We're talking thousands and thousands of cases, could be any number of reasons, and in fact every justice may have their own reason in a particular case for not hearing it. Denial of cert really, from a legal standpoint, means nothing at all. All denial of cert means is that the case did not get 4 votes for review, and this is something that kind of drives me crazy because oftentimes newspapers, websites, others will say, oh, the Supreme Court, ruled on something today or expressed its view on something today simply because they refuse to hear a case, and that's not true at all. The court has said nothing. Denial of cert also, however, simply means that the lower court decision stands. So whatever ruling was made at the lower court, that is the final ruling. And importantly, decisions or cases where cert is denied establish no precedent whatsoever. So they're not supposed to be cited in later cases. No opinions are typically written. It just didn't get 4 cases. 4 votes. You didn't have at least 4 justices who thought the case was important. And again, denial of cert is saying nothing at all about the underlying legal issue. Now, denials of cert, again, there are more than 9,900 of them each year, and most of them, all the court says is cert denied. They give no reason, there's no explanation, there's no opinion. But every once in a while, there will be dissents from denial of cert. Sometimes, what this means, of course, is that the court has turned down a case, it has decided not to hear a case, but the justice wants to hear a case, and they voted in favor of hearing the case, but they lost. And sometimes, it doesn't happen often, but sometimes 1 or more justices will write a dissenting opinion saying, wow, I really wish that we had heard this case. The court should have heard it. One of the most famous examples in the history of the court was what occurred over a period of years with the Justices William Brennan and Brennan Marshall. William Brennan and Thurgood Marshall were two of the most liberal members of the Supreme Court in the 1960s, 1970s, into the 1980s. And they were very strongly opposed to the death penalty. They believed that the death penalty, capital punishment, violated the cruel and unusual punishment clause of the Eighth Amendment. And as a result, every single time that a death penalty appeal came to the court and that the court denied cert in those cases, they dissented, usually with a one-sentence opinion saying, consistent with our beliefs that the death penalty is unconstitutional in all cases, we would have granted review in this case, and we therefore dissent from the denial of cert. And they did this more than 2,100 times over the course of their career. Now that's kind of unusual, but just to highlight a more contemporary example of a dissent from denial of cert, just last year in 2019, Clarence Thomas dissented from denial of cert in a case involving Planned Parenthood. And of course, Planned Parenthood is a very controversial organization in American politics. And in the case of G v. Planned Parenthood, it was a very complicated case. I'm not going to get into the details, but the upshot is that the case would have affected funding for Planned Parenthood. And so the court in this particular case denied cert, but Clarence Thomas dissented and wrote a dissent, and he was joined by Neil Gorsuch and Brett Kavanaugh. So first of all, this is kind of interesting because this demonstrates that 3 of the justices wanted to hear this case, but 6 others clearly did not, and so the court did not hear it, and there was no justice who joined 3 to give Thomas, Gorsuch, and Kavanaugh their 4th vote. But they argued the court should have heard the case, and Clarence Thomas made the argument that the reason that the court didn't hear this case was politically motivated. Some tenuous connection to a politically fraught issue does not justify abdicating our judicial duty. If anything, neutrally applying the law is all the more important when political issues are in the background. So he argues that the court was behaving politically in this case by avoiding a political hot-button issue. But of course, the court always acts politically, and his very act of dissenting is itself a political act. So it's very rare that there's actually a dissent from a denial of cert, and when they do happen, they almost always go unanswered, meaning there's no response. But it is possible, and it is allowed for a justice to write a response to explain why they voted to deny the case. So this would be written from a justice who turned the case down and is explaining why they turned the case down and answering whatever criticisms or allegations or arguments that are made by the justice that dissented from the denial of cert. Now, I'm not going to go into the details right now, but one of the most famous, which I will discuss later in the semester because it's very, very compelling, was a case called Callens v. Collins. This was a death penalty case, and the court turned it down, so the death penalty was going to proceed. Justice Harry Blackmun wrote a dissent saying that the court should have decided the case, and Antonin Scalia responded with another opinion explaining why the case was not worth hearing. And again, we're going to read some excerpts from those two from that dissent and the response later on in the course. So the last thing I want to talk about in this particular lecture is that even though cert votes are supposed to be about whether or not the case is important, in fact, the vote whether or not to grant review can be very strategic, meaning the justices can use these votes in order to achieve their goals. Political scientists start with the assumption that justices want to achieve certain policy goals and that they use their power to do that. And so in this case, political scientists have found evidence that in some cases justices use their cert votes to try to bring about their own policy goals, or at least to try to stop things that they don't like. So again, cert is supposed to be about the significance of the case only, whether the case is important. But justices sometimes do cast their votes in a way that helps them achieve their policy goals, and I want to talk about two of those kinds of things that political scientists talk about: defensive denials and aggressive grants. First, let's talk about defensive denials. So let's say that there is a case from the lower court, it's been appealed to the Supreme Court, and there's a justice who thinks the case is important. They think the case is important. If the case is important, then of course they should vote to grant cert, because that's what cert is all about. Is the case important? If it is, you should grant cert. But the justice thinks the lower court decision is wrong. That's interesting. So you would also think you would want to grant cert in a case like this because it's important and the lower court got it wrong. So this justice should very much want to grant review in this case. But they vote to deny cert anyway. Why would they do that? Why would a justice who thinks the case that's being appealed to them from the lower court was not only wrong, but that it's important, why would they vote to deny cert? Well, in some cases they would, and in some cases that would be a very rational thing for them to do. Because imagine that you are a liberal justice on the Supreme Court right now. What if you thought that, yes, the case is important, the lower court decision is wrong, but if the case comes to the Supreme Court, the majority will uphold it. So in other words, the Supreme Court will reach a decision that is against your wishes and you will wind up being in the minority. Well, in a case like this, a vote to grant cert would actually make things worse. This lower court decision you may think is bad, you think it's wrong, but right now, all it is, it's a lower court decision. It's not a Supreme Court decision. If you grant review, if it comes to the Supreme Court, and if a majority of the court votes to uphold that terrible decision from your point of view, then you would simply be making things worse, because now that bad lower court decision from your perspective would now be elevated to the level of a Supreme Court precedent, binding on all other courts and binding on the Supreme Court itself. So in a situation like this, you would be wise to defensively deny this case in order to contain the damage to the lower court level. And in fact, political scientists have evidence that this does indeed happen from time to time. The flip side of a defensive denial is known as an aggressive grant. With an aggressive grant, once again, the justice thinks that the case is important, but this time the justice thinks the lower court was right. Well, if you think the lower court was right, then maybe you don't want to grant review because there's no reason to overturn it. But in this case, you would vote to grant cert anyway. And you would do this because in this case you suspect that a majority of the court will uphold the lower court decision. So if you like the lower court decision, then of course you have an incentive for the case to come to the Supreme Court, because now you suspect that the Supreme Court will establish a good precedent for the entire nation. And so you will aggressively vote to grant review in this case. So again, we've got some examples, and later on in the course we'll be having a case study of one particular case where we'll see how some of this comes into play. Well, that's it for this lecture on the politics of the writ of certiorari, but we have additional things to talk about with regard to the Supreme Court's agenda setting.